Good morning, friends. Legal Breeze welcomes you for yet another discussion on an important topic relating to the comparison of writ jurisdiction of the High Court and Supreme Court. Please remember, we have already extensively discussed about the writ jurisdiction of the Supreme Court under Article 32. But in this program, we will be discussing the writ jurisdiction of the High Court, and we will compare and contrast the same from the writ jurisdiction of the Supreme Court. Please remember, both Article 226 as well as 32 enjoys the status of basic structure of the Indian Constitution by virtue of various pronouncements of the Supreme Court, right from Chandrakumar case and national taxation case. These things we may discuss it separately when we are discussing about the High Court jurisdiction exclusively. But please remember, both of them have certain identical purposes, but both of them have certain differences. That alone we will be discussing in this program. Please remember, Article 32 itself is a fundamental right, whereas Article 226 can be used for the purpose of enforcing the fundamental rights, but 226 per se is not a fundamental right. This is the big difference. Then Article 226 can be used for enforcing fundamental rights as well as non-fundamental rights. Any legal right or constitutional rights, or it simply uses the term other than any purposes mentioned under Part 3 of the Constitution, that is Clause 2 of Article 32 of the Supreme Court. Please remember, the High Court can exercise the powers without derogating the powers from the Supreme Court. That means High Court's powers are only supplementing and cannot conflict with the Supreme Court. This is a very important restriction enforced by imposed by the Constitution upon the powers of the High Court. So there cannot be conflict between the High Courts and Supreme Court when you are issuing the writs, including for the purpose of enforcing the fundamental rights as well as non-fundamental rights. These are the few things one should keep in mind. Apart from that, there are few more differences. 32 is very silent. Say example, the Supreme Court can issue writs against whom? This is very implicit. Okay. On the other hand, High Courts can issue writs against three categories of persons. One, any person. It may be natural as well as artificial. Two, against any authority. It may be juristic, constitutional, or other things. Then it says, including any government. It may be central government, state government, local governments, all these things. Whereas Article 32 doesn't mention specifically or explicitly against whom the writs can be issued. But it is presumed the High Court can issue writs against any entity, authority, persons necessarily, because when such a power is given to the High Court, one cannot argue that power is not available to the Supreme Court. This is very important. Another question you may ask it, that when the Supreme Court is empowered to issue writs only for the purpose of enforcing the fundamental rights, whether the Supreme Court does not have such a power to enforce the other rights other than the fundamental rights. People used to say the answer is no. No, that is not right. That is totally wrong. Article 226 say example, Article 226 is a combination of Article 32 and 139 of the Supreme Court. That's very important. Article 32 of the Constitution empowers the Supreme Court to enforce the fundamental rights by issue of writs, directions, and other orders. Okay. On the other hand, the same Article 139 empowers similar powers to the Supreme Court to enforce by way of writs, orders, and other direction for the purpose of enforcing other rights other than the fundamental rights. However, such a power can be vested upon the Supreme Court only by way of law of the Parliament. So it's a discretion is given to the Parliament whether Supreme Court can exercise such a power other than the fundamental rights. Okay. Whereas that discretion has been taken away from the Parliament, Constitution itself directly vests such a powers upon the High Court to issue the writs, orders, and other directions for the enforcement of fundamental rights as well as non-fundamental rights. That's the only distinction. However, in modern jurisdiction, Supreme Court is keep on expanding Article 142, that is the complete justice clause, and ancillary clause, and 141, that is the law laid down by the Supreme Court, precedent power, court of record, all these things. So one can safely assume as an inherent power necessarily Supreme Court can exercise for the purpose of enforcing the fundamental rights as well as non-fundamental rights through its jurisdiction. So this is, so one, you should remember Article 32 plus 139 plus 142, right, is a combination of all these things vested under Article 226. So 226 is very wider, whereas Article 32 may be slightly narrower than that. But however, territorially speaking, Article 32 is throughout the country. Sometimes it can be done even extraterritorial authorities. That may be feasible. Whereas such a power is not available to the high courts under Article 226 to a limited extent. But there is one more aspect one should remember. Article 226 can be simultaneously exercised by more than one high courts, because under clause 1 it says that the high court shall exercise the power so and so. Okay. On the other hand, it also confers such a similar jurisdiction to the other high courts. In that case, the article says the high court may also exercise. Right? What is the condition? When the cause of action has arisen wholly in a particular territory, then there is no such power cannot be exercised by other high courts. But when a cause of action takes place partially in one territory of the high court and remaining takes place in the another territory of the high court, both high courts can exercise such a power. So how the conflicts can be resolved? The conflicts can be resolved by way of Article 139A. The Supreme Court may take the cases directly before it and resolve the same to avoid the conflicting jurisdiction. So these are the few things you may keep it in mind. And interim orders can be vacated by virtue of certain provisions under Article 226. These are the things which is not mentioned under Article 32. That is not the subject matter of Article 32. But however, everything is feasible by virtue of Article 141, 142, 32 and 139. Please remember, 136 have been declared as a basic structure of Constitution of India. But 139, I am afraid, has not been declared as a basic structure of Indian Constitution. On the other hand, Article 226 and 227 have been declared as basic structure of the Indian Constitution by the Supreme Court. So these are the few articles which you should remember, that is 32, 139, 141, 142 in relation to the Supreme Court, Article 226 and 227 in relation to the high courts of the states are concerned. If you have any doubts, please put it in the comments box. I would like to answer you. Otherwise, we would like to conclude this particular program is concerned. But before I conclude, as usual, I would like to thank all my listeners and viewers, you and my beloved students who are rendering a valuable service in dissemination of this knowledge to all of you through this channel is concerned. God bless you all. Thank you. Jai Hind.